I'm Adrian and I'm an associate in the IT and Data Protection Group. Today I'm going to be giving a brief introduction to the topic of contracts and the role they play in the world of startups. In particular, I'll be looking at how contracts can protect you and your company from liability, and also how they can help protect your greatest asset, your intellectual property. First, it's important to be aware that anything and everything can form the basis of a contract, and you enter into them all of the time. From parking your car in a car park to visiting a website, or even just an exchange of emails can form the basis of a contract. Moreover, contracts can be oral, they can be written, or they can be created by performance, or any combination of these. So you need to be particularly careful when starting up a business that you're not exposing yourself or your company to undue liability or commitments that you're not actually aware of. So what constitutes a contract? To form a contract, there are several elements that need to be present. There needs to be an offer, which is just making an offer to someone to do something. And there needs to be acceptance of that offer. But that acceptance needs to be unequivocal, and you need to accept the whole offer. You can't just take part of it and say, no, I'm not interested in the rest. Most importantly for startups, one key element of forming a contract is an intention to create a legal relationship. And this is because the law often doesn't recognize as this type of legal relationship in the context, they don't recognize this in the context of a family or a domestic setting. And this is important for startups because often your first port of call, whether it's for seed funding or just to get people to help out with your business, is from your family and your friends. So you need to be clear when you're asking them to help, whether you're intending that this be a formal legal relationship. Because if it's not, you may find that having asked your friend to help cut some code for your website, that it's actually your friend and not you or the company that will own the code in what they've just created. The final 2 points that are necessary for a contract to be formed is certainty of terms, which just means that all the key provisions of the agreement need to be certain and you can't have deferred for later agreement certain key provisions. And finally, there needs to be consideration that passes between the parties, which is just something valuable that the parties exchange, and that can be a promise or it can be money. Contracts are vital for startups, especially online startups, which won't be able to launch without putting certain contracts in place. More generally, contracts can help you guard against the risk of unlimited liability for you and your company, and can help you address key issues such as who owns valuable intellectual property that's created when starting your business. Now, in the first slide, I mentioned that almost anything and everything can form the basis of a contract, and that's true. However, certain documents make this issue slightly less clear, and these are things like heads of terms, memoranda of understanding, and letters of intent. Are these legally binding contracts? Well, it depends. The status of these LOIs, MOUs, and heads of terms, and even side letters, really depends on how you draft them. The best thing to do is to be really clear and express about what you intend, and you can set out whether some or all of the clauses in that type of document are intended to be legally binding. Another key thing to remember when using these types of interim agreements is that you can't leave certain fundamental components of that document open for later agreement. You need to have certainty as to what the parties are promising to do for each other. Otherwise, the contract can fail for uncertainty. And while a court may be able to piece together an actual agreement from, a partly written contract, emails that you've exchanged between the parties, or even oral statements that each party has made to each other, if it's not sufficiently clear what the intention was of the parties from the outset, a court's not going to be able to make up an agreement for you. Where the real risks arise for startups is when one or both of the parties start acting or proceed to act on the basis of these interim agreements, because there may be a dispute or uncertainty later on as to whether a contract was formed in the first place, and if it was, what were the key terms. So while it may be easier to agree a really short form letter of intent, we'd always recommend that you take time to be clear on what the key provisions are and whether they are intended to be legally binding. Things like, what are you purchasing from the person? How much are they meant to pay? When are they meant to deliver it? And who's going to own the intellectual property that may be created throughout the course of the engagement? There are a number of contracts which all businesses are going to require when starting a business. I'm not going to focus on the corporate side of things, such as funding agreements, shareholder agreements, and articles of association. Instead, I'd like to highlight the variety of other agreements which you may need to consider when starting a business. What type of contracts you're going to need is going to depend largely on the type of business you are. So the needs of the next Amazon or eBay are going to be quite different to the needs of the next Facebook or YouTube. But if you are considering any type of online presence, whether a website, an app, or a new e-commerce platform, you need to think about how some or all of the types of agreements which appear in the slide fit together. Do your conditions of sale fit with your website terms of use? And does your privacy policy and your cookie policy give a consistent message as to the types of personal data that you'll be collecting and what you'll do with it? There are a vast number of documents which you'll need to put in place as a startup. Some will be customer facing, like a privacy policy or the terms of use that your customers and users will use and need to review. And others will be your back-end style contracts, which are necessary to run the business. And this could be things like a web hosting agreement. One of the key takeaways though from today should be that you need to ensure that your front-end customer agreements and your back-end agreements fit together in a way that helps you manage your liability and allows you to deliver on the promises that you make to your customers and your users. For example, if you say to your users, we will comply with our data protection obligations and we won't transfer your data out of the EEA without your consent, you need to make sure that your hosting provider is either based in the EEA or that there's an obligation on them not to transfer any personal data that you give to them out of the EEA without your consent. Finally, I wanted to talk about how contracts can help protect the most valuable asset that most startups have, which is their intellectual property. A recent report from one of the global accounting firms estimated that more than half of the value in the average listed company is comprised in what they called intangibles, which are largely going to be made up of intellectual property rights. And this is even more the case with startups, where there aren't many tangible assets and your value proposition is in the things that you bring, your intellectual capital and the intellectual property that already reside in your business. As a general starting point, whoever creates the intellectual property will be the owner of that intellectual property. So if you're cutting code and you're creating new code, then you'll own the copyright in that source code. There are two scenarios, however, that I wanted to touch on briefly. One is a situation where intellectual property has been created by the founders of the company before the company was formalized and incorporated, and also intellectual property that's been created by consultants or contractors. First, if certain intellectual property, whether it's source code or it's the registration of a trademark for your business name, if this has been created by one of the founders prior to incorporating a company, that intellectual property right is most likely going to be owned by the owner, not by the company. So you need to consider putting in place an agreement, whether it's an IPR assignment or something in your founder's agreement, that assigns all the intellectual property that may have been created prior to the incorporation of the business and assigns that to the company itself so that it doesn't reside personally with each of the founders. The second thing you need to be wary of is if you're using contractors. And by contractors, I'm talking about consultants who you may engage to provide any type of services to you, but it's also going to capture your friends and your family that are helping you out in providing inputs into your business. They may be helping you design your website, they may have designed your logo for you. Because without an agreement in place, those individuals will own the intellectual property, whether it's the copyright, and other types of IPR in those things that they've created for you. So you need to put in place a contract that effectively assigns that intellectual property to the company so that you can be sure that your company has everything that it needs to continue to function. One of the key exceptions to that rule that whoever creates the IPR owns the IPR is if an employee creates the intellectual property in the course of their employment. In that case, the employer is likely to own the IPR that's been created. Even though this is the case, we would always still recommend that in your employee agreement, you put in place provisions that make it clear that the intellectual property is being assigned to the employer or to the company. As a final point, another important way to protect your intellectual property rights is by use of confidentiality agreements. Being first to market is really important for some, if not all, startups. And NDAs or non-disclosure agreements and confidentiality agreements are a good way to ensure that your idea doesn't get out into the public domain before you want it to. And moreover, for certain intellectual property rights, such as patents, it's essential that you keep confidential and secret the actual nature of your invention or your new idea, so as to not invalidate your own patent claim when you seek to try to protect it by registering the patent. Today, I've only just scratched the surface of the types of contracts and agreements that you will need to put in place when starting a startup, but I hope that this introduction has been a useful one for you. Thank you.